Welcome to this Federalist Society virtual event. My name is Edith Harold, and I'm an Assistant Director of Practice Groups with the Federalist Society. Today, we're excited to host this FedSoc forum called The California Wildfires and America's Housing Challenges. Speaking with us today, we're joined by Nolan Gray, Jennifer Hernandez, and Professor Ilya Soman. And moderating the discussion today, we have Stephen Davis, who is a senior legal fellow in the Pacific Legal Foundation's Constitutional Scholarship Group. His work focuses on the study of property rights as safeguarded by the United States Constitution and common law. Prior to joining PLF, Steve litigated property rights cases representing hundreds of landowners across the country in federal courts from trial through appeal. Steve also served as an assistant United States attorney for the Eastern District of Missouri and as the chief clerk and administrator of the Missouri House of Representatives. If you'd like to learn more about today's moderator or speakers, their full bios can be viewed on our website, fedsoc.org. Throughout the program, we may turn to the audience for questions. If you have a question, please enter it into the Q&A function at the bottom of your Zoom window, and we will do our best to answer as many as we can. Finally, I'll note that, as always, all expressions of opinion today are those of our guest speakers and not the Federalist Society. With that, Steve, thanks so much for joining us today, and I'll hand things over to you.
Thank you, Edith, very much. Can you hear me? I'll just assume you can. All right. Well, thanks everyone for joining, and we'd like to thank the Federalist Society and especially the Executive Committee for the Environment and Property Rights for hosting us today. We have wonderful experts, and we're looking forward to a very enjoyable webinar. So we're talking about the California wildfires and America's housing challenges. As my own law firm has said, Pacific Legal Foundation, housing costs have skyrocketed in recent years, signaling a national housing crisis. As Jim Burling explained in his book, Nowhere to Live, he said, simply put, we're simply not creating enough housing. And at the core of our inability to create enough housing, we have government policy after government policy that prevents needed housing from being built. Professor Soman, who's with us today, he's written recently that even before the fire, the LA region had a serious housing shortage caused in large by exclusionary zoning. Some 78% of the residential land in LA is zoned for single-family residences only, which makes it extremely difficult to build new housing in response to demand, especially multifamily housing affordable for working and lower middle-class people. So the California wildfires have only exacerbated California's housing crisis. Today, I saw that the LA Times reported that as of last week, 72 property owners had submitted building applications to the city, and the city has approved permits to rebuild three homes in Pacific Palisades, with an additional 98 owners who have filed permit applications with LA County for rebuilding in unincorporated areas. So can potential regulatory reforms in California serve as a model for other states to alleviate and address the national housing crisis? So we have three wonderful, knowledgeable experts with us to discuss these questions. We'll begin by hearing from Nolan Gray, and then Jennifer Hernandez, and then lastly, Ilya Soman. I'll introduce them just briefly. Nolan Gray is the Senior Director of Legislation and Research for California YIMBY and an expert in urban land use regulation. He is the author of Arbitrary Lines, How Zoning Broke the American City and How to Fix It. Nolan previously worked as a planner in New York City, where he worked on the front lines of zoning. He is a widely published author with work appearing in outlets such as The Atlantic, Bloomberg City Lab, and The Guardian. He lives in LA and is originally from Lexington, Kentucky. Next, we'll hear from Jennifer Hernandez. Jennifer has practiced land use and environmental law for more than 30 years and leads Holland and Knight's West Coast Land Use and Environmental Group. She's a former longtime co-chair of the firm's National Land Use and Government team. She represents clients and projects in the Bay Area, Southern California, and Central Valley communities. She has written 3 books and more than 50 articles on environmental land use topics. And she regularly teaches land use, environmental and climate law in law and business schools, colleges, and seminars. Before beginning her land use and environmental law career, Jennifer graduated with honors from Harvard and Stanford Law School and clerked for Region 20 of the National Labor Relations Board. Finally, Ilya Somin. Professor Somin is a professor of law at George Mason University and Simon Chair in Constitutional Studies at the Cato Institute. He is the author of notable books including Free to Move, Foot Voting, Migration, and Political Freedom, and The Grasping Hand, Kelo versus City of New London and the Limits of Eminent Domain, and Democracy and Political Ignorance, Why Smaller Government is Smarter. And he is also a frequent contributor to the Volokh Conspiracy blog, which is affiliated with Reason magazine. His writings have been published in the New York Times, Washington Post, Wall Street Journal, CNN, The Atlantic, and elsewhere. So we are very fortunate to have our experts. We will start with Nolan Gray, who I hope can, since Nolan, you're on the ground there in LA, you can give us hopefully an update on how things have been going.
Yeah, well, thanks so much, Stephen, and thanks to Edith and the Federalist Society for having me. And it's great to be chatting with Ilya and Jennifer, 2 people whose work I really admire. So let's set the table a little bit. Even before the wildfires in January, LA was in the midst of a debilitating and worsening housing crisis. We had a housing shortage numbering in the hundreds of thousands of units. We simply weren't building enough housing, period. As a result of this, we had one of the highest rates of rent burden in the country, of households spending more than 30 or in some cases 50% of their income on rent. Of course, we have one of the highest homelessness populations. And of course, that's multifactorial. A lot of people struggle with homelessness because of substance abuse issues and mental health issues, but also core to this issue is a simple lack of housing and the high prices that result from it. And then, of course, we had, in the most extreme cases, many tens of thousands of people simply leaving the region, not because of our amazing weather or our great jobs or our strong economy, but because they simply couldn't find a home. One of my former Mercatus colleagues likes to joke, Los Angeles has a fabulously successful housing affordability program. It's called Moving to Las Vegas. If you want an affordable home, move to Las Vegas. So that's where we were at in January. Excuse me. The policies contributing to that were pretty straightforward. As Stephen mentioned in the introduction, 80%, approximately 80 to 85% of residential areas of Los Angeles are altogether off limits to any additional housing production. Those parts of the city that are open to housing production, it can take a year, 2 years, 3 years to get a permit. It can require a long and costly environmental report and all the litigation that follows from that, as Jennifer can, I'm sure, speak to. It involves multiple public hearings. It involves extremely high impact fees. So what we get is a situation where the occasional project that can pencil is, of course, extremely expensive. And then January came. Then the crisis starts. We lost about an estimated 16,000 structures in LA County. Hundreds of thousands of people were temporarily displaced. You know, we're talking a lot about the homes that were destroyed. Many thousands more homes are going to need to be repaired, and many thousands more families are likely going to want to move or undertake serious work to modify their homes in response to this crisis. And we are simply not prepared to respond to this crisis. We weren't prepared to respond to the crisis that we had before the fires, and all of this has been kicked into high gear. One thing I would flag, because I speak all across the country, and I find that folks are like, well, California is weird. I would stress that a lot of the policies that California has on the books, of course, some are weird, like the Coastal Commission, Environmental Review. Those are a little bit unusual. Your typical state doesn't have them. But your typical state does struggle with things like zoning that makes it impossible to build housing and could very easily struggle with slow permitting. So if you think California is weird, just sit tight for 10 years. And your state could very well be in the same situation if we don't deal with the underlying structural factors here. So far, I've been very distressed by the response to the crisis. I think it's revealing a lot of deeper governance issues in California. Of course, there has been some fantastic leadership, but there's also been, I think, a lot of disappointments. At California YIMBY, we're continuing to work on making sure that it's as easy as possible to build housing in safer areas of the state, existing urbanized areas, areas of the state that have easy access to high quality jobs, rather than continuing to force all of the housing production onto the potentially at-risk periphery. A couple of bills that we're working on to this effect. I'm happy to go into more details, but working on bills to allow for third-party licensed architect and engineers to review permits when cities take longer than 30 days to review permits, clearing out this backlog of permitting, making it easier to build in areas near transit or near job centers, in many cases where land prices suggest that there's the highest unmet demand and onerous government regulations pose the biggest threat. And then just increasing options for homeowners. One of the distressing things that I saw in the immediate reaction to the fires was some local elected officials and activists were immediately saying, let's start exempting these areas from the limited protections that state housing law afford these people, and let's exempt them from laws that might allow a family rebuilding to add an accessory dwelling unit, or to build a duplex and live in one unit and rent another unit out to a family that was displaced, or to adult children or aging parents. The way that we help folks who are affected by these fires is to maximize their options with what they do with their property, to restore their property rights and protect their property rights. And then two, to make sure that whatever path they choose to go on, they're not spending months or years waiting on a permit. So I'll leave it there. We have some really fantastic people on this panel, and I look forward to the conversation.
Yeah, thank you very much, Nolan. Next, we'll go to Jennifer.
Well, thanks very much. And I, too, am a longtime admirer of Nolan's and Ilya's work and of Pacific Legal Foundation, Federalist Society. So thanks for letting a Berkeley Democrat in the door. I'll just start by reaffirming everything that Nolan has said. California had really, as a land use environmental lawyer who speaks fluent acronym, done every conceivable thing to make it harder to build a house that people can afford. And I use the term house not to necessarily focus on a single family home typology, but I am focused on a home ownership product that is attainable to median income families. If you don't have that attainable home ownership, which is roughly 3 to 5 times median income, then the market falls apart on both edges. People who should be able to buy continue to rent. That rent market then strains the availability of rental units, and it increases rent prices, and filtering just doesn't happen. Instead, for years now, California housing policy has tried to create sort of the Ezra Klein everything bagel solution to every stakeholder who has dip their straw, to mix metaphors, into Sacramento. For families who rent homes at, quote, market prices, rent apartments, need to subsidize permanently a 5th apartment for a lower income family. And that's the way a 20% inclusionary housing requirement works. New housing has to pay for everything, including what other incumbent residents get for free, like access to parks or schools that are paid for through normal property taxes. So all of these issues, including an incredibly complicated and ever expanding set of local as well as state and regional regulatory requirements that now, keeps 30 lawyers in my group busy full time with stuff that really should be architects and engineers. It has created an impossible situation where you can get a permit, you're building. In fact, we had testimony recently from an affordable housing builder who had built exactly according to the permit they received, was at the 90% approval stage for a low-income multifamily housing unit. And the Public Works Department came and said, no, you need another stairwell. And many months later, a couple $1 million later, the loss of multiple units later, there's another stairwell. But we can't even count on being able to implement approvals as written because of disagreements between agencies or within departments. all of that, I'm sad to say, is on full display as the city and county both struggle with every best intention to take that structure and apply it now to an emergency situation. And the fires are an emergency situation. But I will just note that one response to the emergency situation is to accelerate rebuild, but it is also to accelerate housing production everywhere in the city and county, or for that matter, the region. Within minutes of those fires, the scale of the fires becoming known. I had clients in southern Orange County, many miles south, that were getting calls from displaced Pacific Palisades family who were having to leave the region because there simply aren't enough housing units. So the idea that the fires are also a reason to accelerate production of housing that's actually affordable to people and creates meaningful homeownership opportunities for the middle class, that just has not resonated. And I think that's frankly a missed opportunity and something of a tragedy that continues to unfold. But it's the tragedy of the last several decades. People are pollution, as one of the California Environmental Quality Act lawsuits are, was framed as, where housing is is a bad thing for the environment, and the people who live in it, well, why do they have to be here anyway? So it's unfortunate. The YIMBYs have done a tremendous job in freeing up local zoning restrictions. We have, though, hundreds of thousands of permitted units that can't break ground because we don't have the buyers or renters who can afford them, and they simply don't pencil. There are very, very high income areas like Santa Monica or Newport Beach or Palo Alto where more projects pencil, but we're just not, with our current laws, creating affordable homeownership products for median income families. I'll stop there.
Thank you very much, Jennifer. Before I get to Ilya, I just wanted to, if you're thinking of questions that you'd like to ask our panelists, please type them in the Q&A. Use the Q&A function. That's the button with the bubble with the question mark in it. And Ilya, we'll turn to you next.
Thanks to FedTalk for organizing this, and to Jennifer and Nolan for their excellent presentations. I'm going to talk a little about the connection between exclusionary zoning and the wildfire situation, but I'll also put this into broader national perspective and discuss how we can address the housing shortage by constraining exclusionary zoning, including by pushing for court rulings that would ultimately rule that exclusionary zoning, at least in most cases, violates the takings clause of the Fifth Amendment, a subject on which I recently published an article in the Texas Law Review, co-authored with Josh Braver of the University of Wisconsin. I'm a libertarian and generally an originalist. He's a progressive living constitutionalist. The fact that we can agree on this issue, even though we differ on many others, hopefully maybe other people can agree as well. And more generally, this issue of housing and zoning is one that tends to bring together experts across the political spectrum, as you can even see on this panel right here. So as Nolan said, and Jennifer as well, there has long been a very serious housing problem in LA and in some other parts of California, and the wildfires clearly exacerbated it. Some 16,000 structures were destroyed in the wildfires. Not all of them were homes. I haven't yet been able to see good data on how many were homes, but probably a very large percentage were. And as Nolan correctly said, many other structures, though not destroyed, were seriously damaged, and for the moment at least are not usable or not fully usable. And all of this exacerbates an already very serious housing shortage, where thanks to zoning restrictions and other rules in most of LA, it's very difficult to build large size multifamily housing units. This makes housing more expensive, but it also increases wildfire risk because evidence shows that there's less of a risk in building up modern structures in more dense city parts of the more dense parts of the city than areas on the periphery, which of course are closer to forests and where fires can more easily spread and the like. So this actually exacerbates future wildfire risks as well. The California state government has taken some measures that could facilitate rebuilding at the margins, like they've streamlined some permit issues. On the other hand, they've also done things that actually may make the situation worse, including imposing quote unquote anti-gouging price controls on building materials. Jennifer tells me those restrictions may not be much enforced, but still contractors may be unwilling to violate them for fear that, the law enforcement could go after them later. And of course, when you impose price controls during a crisis, that reduces the supply of the needed materials and makes rebuilding slower and more difficult. That's just economics 101. More generally, in most places, as I understand it, you're not allowed to rebuild by building housing that's different from what was permitted before, and that makes it difficult or impossible to build new multifamily housing, even though multifamily housing is often what is most affordable to the working class and the lower middle class, the people who most suffer from these shortages. Now, as Nolan said, some people do perceive this as just a California problem. They're like weird in California, but sadly, exclusionary zoning is actually a problem in much of the country. Lots of data reveals this. There's even that problem exists right here in Arlington, Virginia, where I live, where we, up until recently, 80% of Arlington was zoned for single family homes only. Recently, the Arlington County did enact reforms that would have allowed so-called missing middle housing to be built up to structures for up to 6 families. But that is now tied up in court because NIMBYs claim that the county didn't sufficiently consider potential impacts of this reform. And Arlington is just one of many places that has severe housing shortages and very high housing prices because we do not allow the building of homes in response to demand. In fact, some estimates suggest that 70-80% of all residential property throughout the United States is zoned for single family homes only, which makes it extremely difficult to build housing that's at all affordable for many people. How did this happen? Exclusionary zoning began in the early 20th century and often for the explicit purpose of keeping out poor people and minorities. In the early to mid 20th century, zoning advocates openly talked about how the idea was we want to keep blacks and other minorities from moving to majority white areas, and also we want to keep working class people from moving to middle class areas. Unfortunately, in a 1926 decision in Euclid versus Ambler Realty, the Supreme Court upheld exclusionary zoning against constitutional challenge, even though the lower court judge whose decision they overruled specifically indicated what is going on here, he correctly pointed out, is exclusion based on socioeconomic status. He also predicted that it would be used for racial exclusion as well, and he was right about that. In the aftermath of Euclid, courts have generally engaged in only very limited constitutional review of exclusionary zoning. Currently, most exclusionary zoning is under the Penn Central test, named after the 1978 Supreme Court decision of the same name, which has a 3-part balancing test for determining whether most restrictions on property qualify as takings under the Fifth Amendment, which they do qualify as takings. The government would have to pay just compensation for imposing the restrictions, but under this 3-part test, at least the way that it's applied, in the vast majority of instances, courts will just rule that there is no taking and therefore you get nothing, even if your property rights are severely restricted. Even if, for example, you're only allowed to build a single family structure and nothing else, which is a severe cost in many cases and severe restriction on your property rights, courts will say, well, under the 3-part test, it's all fine and you get nothing. I, along with Josh Braver, we challenge this approach. And if you look back from an originalist point of view, if you look back in 1791, when the Fifth Amendment was added to the Constitution along with the rest of the Bill of Rights, you find legal authorities of that era clearly saying that what was protected by the takings clause and a key component of the property rights involved was not just the right to exclude people, which we think, many people today think that's the central component, but also included the right to use property. For example, William Blackstone, the great English legal theorist from whom early Americans took many of their ideas, he said that property includes the free use, enjoyment, and disposal of all his acquisitions. And similarly, James Madison used a similar formulation when he presented the Bill of Rights to Congress, clearly suggesting that the right to use property was one of the rights that was going to be protected. Some originalists argue that when we determine the original meaning of the Bill of Rights as applied to the states, it should be that of 1868, when the 14th Amendment was enacted and the Bill of Rights first became applicable to the states, and not that of 1791. For that era, we have even more evidence that the right to use was a central component of the property rights protected by the Takings Clause. Contemporary decisions like the Pompelli decision of 1871 and the Eaton decision around the same time, they emphasized the right to use as part of the property right that was protected, and so did leading legal treatises of that era, such as that written by Michigan Supreme Court Justice Thomas Cooley. Obviously, not everyone is an originalist, though perhaps in this FedSoc event, many of the audience are. In our article, we also talk about how leading living constitutionalist theories also come down on the same side. I won't go through all of them here. I'll just mention one. A very common view among living constitutionalists is that the court should be doing representation reinforcement. That is, it should be protecting people and groups that are vulnerable in the political process and do not have the ability to fend for themselves. This situation is nearly a textbook example. I've already mentioned the ways in which the poor and minorities have historically been victimized, but also, even aside from that, the biggest victims of exclusionary zoning are people who are not able to move to the communities where the exclusionary zoning exists, and as a result, they are deprived of opportunities, and the national economy is severely damaged to the point of massively reducing our productivity and our GDP. Those people who are excluded by the political process in these communities, they have no ability really whatsoever to participate in that process. They can't vote in elections there. They generally have little opportunity to lobby zoning boards and so forth. So it's a classic case of excluding people from political opportunity and thereby harming them. And it's a classic situation where judicial review under this theory is supposed to step in. I do not propose that judicial review be the exclusive mechanism by which we combat exclusionary zoning, but it can help. And in the article, we point out how in the past, successful constitutional reform movements have generally simultaneously used both litigation and political reform of the kind that Nolan and Jennifer are involved in. Usually there's a synergy. That happened with the civil rights movement, the women's rights movement, and also previous successes that property rights advocates have had as well. This is the biggest, I think, constitutional property rights issue of our time. It's not in my interest to say that because I've written a lot on other issues, but it is true nonetheless, and I hope we can do more to address it. Thank you so much, and I very much look forward to questions and discussion.
Thank you. Thank you, Ilya, and thank you all three of our panelists. Before we get to audience questions, and again, to our audience, please use the Q&A feature in the menu to submit your questions. Before we get to those questions, I'm going to ask our panelists if they have any comments on what each other have said. So whoever wants to go first.
Yeah, I'll just say to the two attorneys on the panel, and I assume the many who are tuned in, the politics of this, the legislative politics of this, certainly at the local level, are really difficult. They get a little bit easier at the state level where the local neighborhood group can't hijack the conversations, but as we've seen in California, it's still very challenging to pass good, clean legislation. So I suspect that a lot of progress is going to be made through the courts of getting back to these first principles about protecting property rights and having some basic semblance of procedural fairness. So, I would say to folks, a lot of these conversations, and especially my framing of it, is really focused on the policy because I'm a legislative advocate. But I think this is going to take progress on all three fronts. We need reform within executive agencies that are administering these laws. We need changes to the laws themselves, and then we need courts that protect people's rights once we've written good bills into law.
I wanted to raise an issue that we haven't touched on yet, but to my mind is quite critical, is you can't really build a house, even if you have a building permit, unless it has electricity, water, sewer, basic infrastructure. And we do not have consensus around how to replace infrastructure in much of the burn area. There's a significant dispute about whether we should ever build in the hills, and maybe that's inherently unsafe. Then we have examples of quite safe communities built in the hills with both community layouts and features like fire water systems and building code compliance that are very safe. As contrasted with the very urban fires, whether in Santa Rosa, the suburb, Oakland, the suburb, or now LA, the suburbs, that have just torn through older housing stock. So infrastructure is like the redheaded stepchild. Let's not talk about it. And it was a glaring omission in the governor's executive orders. We also have this notion that, we should be able to evacuate quickly and efficiently. You can't do that without roads that are wide enough, which you can't do easily in canyon conditions, especially if you allow on-street parking. And especially if you think about there has to be incoming emergency vehicles and outgoing evacuation residents. That requires some road width. But we're quite hostile to roads. We think that as long as we don't build new roads, no one will drive, even though, according to the regional organization that manages transportation in Southern California, 97% of people use a car to get to and from work. So it's kind of an everything bagel thing. It's like, let's make these communities walkable and bikeable. Absolutely. But how do we actually protect public safety? And then finally, on sort of a related infrastructure issue, we have this notion of protected open space that comes right to the fence line of the backyard. And protected open space, our ethic has to be allowed to, be wild. In a new community context, there has to be a fuel modification zone. There has to be emergency access in that managed vegetation buffer area, as well as the, much more robust fire water protection systems and whatnot. But to encroach with a safety buffer into protected open space is another one of those things we just pretend we don't have to do. And then there's a catastrophic situation and everybody points fingers at each other. And that is occurring. So I would say infrastructure and the open space, the protected open space that, comes right to the edges of these communities without the appropriate buffer and management structure are additional challenges that California is terrible at confronting, and we're not rushing to confront that here either.
I guess I would just want to briefly expand on some of the things I said earlier by making the point that, as you saw from the other two presentations, often in California, but also elsewhere, you end up with a kind of cat and mouse game that even if you loosen one restriction on building affordable housing, there's still a whole bunch of other regulations that can get in the way. And that makes it extremely difficult to address the problem. I do not claim that litigation or constitutional judicial review can fully solve this, but one of the advantages of a takings clause that more fully enforces the right to use through judicial review is that right to use is a general principle that applies to all of these restrictions and can potentially be used to attack a wide range of them. There is a category of restrictions that it might not override because there's the so-called police power exception, where some rules that otherwise might be considered takings are exempt from that on the grounds that they protect public health or safety. But as we argue in our article, that should apply only to situations where the government's regulation is preventing some unusually great risk to health or safety, like your building structure is a home for diseased rats that would spread disease or something like that, or it's a major fire hazard or the like. It should not be used to suppress things which cause small risks or the kinds of risks that are just unavoidable in everyday life. So judicial review can be a helpful tool to overcome what would otherwise be sort of multiple layers of restrictions that are very difficult to deal with on a case-by-case basis through legislation, though in principle you could have more sweeping statewide legislation that sort of preempts all or most of these things, but politically that's often difficult to enact because you have to deal with a wide range of different kinds of interest group opposition.
All right. Well, I appreciate those additional comments. Now we've gotten some questions from the audience. And again, if you're in the audience and would like to propose a question, please use the Q&A feature. Our first one comes from Jeff Wood. Regardless of nefarious purposes to which zoning may have been put in the past, such as racial discrimination, it has functioned to create residential, industrial, office, retail, etc. areas. If zoning is removed, do older land use restrictions, such as covenants running with the land, negative easements, etc., fill the gap so that your neighbor doesn't open a pig farm next door, or that a very strong degree of liberty in using one's property, or is that very strong degree of liberty in using one's property the goal?
I can only speak for myself, but I would say to a large extent it is the goal. But I would note, as I've written in my work on this, that there is a difference between private land use restrictions and government-imposed zoning. Only government-imposed zoning or other government-imposed restrictions would qualify as a taking and would raise constitutional problems. And so some people say, well, wouldn't the private restrictions work the same way? And my answer is no, because the private restrictions can only be imposed with the unanimous consent of all the property owners that are covered. So it'd be extremely difficult to impose massive restrictions on housing construction or other kinds of construction throughout a vast area, throughout a whole city or a metropolitan region like we see now with exclusionary zoning. That does mean that some people would have to put up with, land uses nearby that they don't like, they are aesthetically unappealing or the like. Some could still be dealt with through the police power exception that I mentioned, like if the land use poses a serious health and safety risk or the like. But there is the issue of if you own a single family home, but people next door would be allowed to build a multi-family home, and that doesn't bother me. I advocate abolishing single family zoning right here where I live in Arlington, but it will bother some people. But I think that is the price of liberty and the price of strong property rights, and the benefits of getting rid of exclusionary zoning are so enormous because it would create millions of opportunity for millions of people, would increase productivity, and might actually increase land values even for existing homeowners, because if your structure can be used for more than just one purpose, that will often increase its value. For those of us who have kids, that would mean that our kids can live in the same neighborhood as we do without necessarily having super high paying jobs and the like. So I think the benefits greatly outweigh these kind of costs, but I do acknowledge, that some costs do occur, and people who are more wedded to the idea that they want their community to remain exactly the same as it is, and it's they don't want its quote unquote character to be changed, or people who don't want a more interspersal of different economic classes in particular areas, they would be unhappy about this. To my mind, this is not a kind of preference that can be imposed on people by force through government, or if it is imposed, at least you have to pay compensation as the Constitution requires.
So without government imposed zoning, so we still have, I guess, zoning by HOA,
Sure.
and you still have nuisance law. Is that where?
Sure. Yes.
That's what I
Although
gathered from.
with HOAs, voluntary HOAs, I think are fine. But in some parts of the country, people are required to have an HOA in that area. And I think those kind of laws are both unjust and also to the extent that they restrict land uses probably violate the taking clause as well.
I'll leave to Nolan maybe an anecdote or two about the politics of trying to apply housing laws within HOA communities, which are something of a challenge. But California has poked through HOA restrictions in a variety of contexts. The HOA restriction against what used to be those big old satellite dishes before cable even fell. HOA restrictions against solar panels fell. HOA restrictions against small daycare facilities fell. Commercial covenants, say for shopping centers, that gave parking rights to major tenants fell, but only for 100% affordable units. So the California legislature, relying on kind of state matters of significant concern, has found fit to stomp on selectively private CC&R arrangements, and that. But that is picking off a whole new set of challenges, because now we have permit approval conditions that also require HOAs to undertake and enforce things like fire-safe vegetation management or recycled water, use requirements and whatnot. So we've in many ways embraced HOAs as another enforcement arm through government action, rather than leave it as an entirely voluntary behavior. So,
yeah, just building on this a little bit. I mean, I think the pig farm case is easy. Cities before the rise of zoning had rules on nuisance uses, on where they could locate. I think that's well established, and I'll say well established in the common law, as if two people on this call don't know far more about that than me. But well established, like cities had rules of this nature for tanneries and for oil refineries and things of that nature. The hard case, to my mind, is people who have preferences about what their neighbors use their property for that go well above a classic nuisance. How do you meet that preference? And I don't know that the government has a valid role to play in that, but if people want to voluntarily opt into contracts that bind one another and place rules on how their neighbors use their property, I think that's perfectly valid. I will say, I think a challenge that we've faced is, now that we're coming up on over 100 years of these sorts of deed restrictions on properties, we have this problem of stale covenants, that are 50, 60, 75 years old, where everybody who was party to the covenant is long dead. The covenant serves no purpose except to block, for example, a homeowner from adding an ADU to his or her property in older neighborhoods built in the 30s or 40s, or prevents them from using state law to engage in a lot split and build a second home on the backyard. So that's tricky, and I think people resent their HOA because of these sorts of government or governance issues. And so I do think like HOAs and private governance of these issues is not a panacea, and we actually need to have a more serious conversation about how these things work, including, I think, going back to a norm of requiring that these restrictions be affirmatively renewed after a set period, or have some sort of mechanism whereby they phase out after literally, 50, 60, 75 years. This has been a big challenge for example, SB 9, which is the duplex and lot split bill. We're working with a developer who's trying to do these projects in Sacramento and older areas of Sacramento that were built up in the teens and 20s. And the single family homes that are well suited to redevelopment in these neighborhoods often have a deed restriction saying you can only use this as a single family home. And so nobody alive cares about that restriction. And yet here it is. And so, that's part of why we get these state interventions into these, what is on some level a violation of contract rights, but in a practical sense, something that everybody who's party to the issue would agree is the right thing to do. So I would just throw that out there for smarter legal minds to think about.
One more quick point while we're on private contracts is there are two huge players in this world that we haven't touched on yet, insurers and mortgage banks. And just like you can't build a new home without electricity, you really can't build a new home without a mortgage, which then requires insurance. And those are effectively cops on the block who are also enmeshed in California's complex swirl of so what now? And of course, just really traumatized homeowners, families who have lost their place to live and want it back. We also have a statewide insurance crisis, and made the state's major insurer almost went bankrupt and may still, although there's an emergency rate hearing scheduled for a couple of weeks from now. So the role of government and a private party in housing needs to acknowledge these important third-party players, mortgages and insurance, and the important role they are playing, sometimes just by creating financial chaos in affecting or delaying change. And they're doing both.
Yeah, thank you for adding that. We had a couple questions asking about insurance in the market and whether people can rebuild, whether they'll be able to get insurance or financing. So, any other thoughts about that, or potential market solutions?
So I'm not as nearly as expert in insurance issues as in land use issues, but I will note, as I understand it, California and some other places have price controls on insurance, and therefore the insurance companies in many cases are not willing to sell insurance in certain areas because they can't charge prices that actually match the actual risks. That makes it hard to get insurance, but it also makes it hard to get accurate signals, market signals and price signals on the risks of building in a particular area. So I would just suggest the Econ 101 solution of eliminating the price controls in this area. And that would make it easier to get insurance, but it would also give people a more accurate picture of what kinds of risks they're facing, by building or purchasing property in a particular area.
Great.
Yeah, I mean, I would say there's two things that have happened over the last few decades. First is a push and a pull factor. Why did so many Californians end up living in places that were quite dangerous and structures that were highly prone to burning down? There was the push factor, which is we've spent the last 100 years making it as difficult as possible to build any housing in existing safe areas. And just so folks know what we're getting at here, of course, sometimes that's an apartment building replacing an old strip mall, but sometimes that's a small lot housing townhouse subdivision on a single family lot that's larger, or an ADU in the backyard. So we spent the last 100 years making it as hard as possible for Californians to build housing in existing resilient areas. And then we dampen the incentives to either avoid or take mitigating actions when you're living in areas prone to fire risk. So by suppressing insurance premiums, et cetera. And so, I think the insurance crisis is going to involve solving both aspects of that. I would say, we can just reduce risk for the pool by simply allowing more housing in places that are safe. But unfortunately, in California, we politicized insurance markets, and it's going to be incredibly difficult to unwind this. A lot of people have made significant investments and entire lifestyle decisions around artificially low insurance premiums. And I don't know that's a solvable problem necessarily politically.
Although I think, Nolan, you and I would disagree about what makes a community safe. For me, it's a lot less about location in an infill-only agenda, and it's much more about designing it to be safe, just like there's nothing inherently safe or not about an earthquake fault. It exists, and so we don't evacuate or prevent building except on the fault itself. But we do impose pretty stringent requirements to make sure those buildings are safe. And that's the same for, edge areas that can be made and have been proven to be made safe for wildfire risk.
I agree. This is, of course, a divisive issue among YIMBYs, but I tend to think a healthy, growing city has to be building up and building out. And it's clear that in many parts of the state, there is unmet demand for new single-family homes on what would be greenfields. Again, not everybody on my team agrees, but the thing that we agree on is infill, and so that's what we work on. But conceptually, I'm with you. I would say if the prices are right and the risk is clear, letting households make these decisions, and they'll usually, I think, make the right decisions about the mitigation measures that need to be taken. To me, that's the most important piece. Is just having the prices and the incentives and the information available. And then having options, right? I mean, we don't know how many homeowners in California ended up in more unsafe areas for lack of an option in a safer infill area. We don't know. And part of what I think the promised land looks like to me is give folks choice, give them prices that give them clear incentives and information about risk, and then see what, where they end up.
All right. Well, we've mentioned that the housing crisis has had one, at least, beneficial impact is in that it's brought people together from across the political spectrum to try and reach a solution or many solutions. Is there any silver lining to the wildfires that you think will help California and maybe the nation as a whole move forward?
I actually think there is. When you make a really large group of really wealthy people really unhappy, there tends to be an opportunity to find change. Prior wildfires, even quite significant ones affecting Malibu, for example, that was kind of over there. That was those people. They were so wealthy, we didn't care. Altadena is kind of a core community. Pacific Palisades is a core community. The change may be gradual, but I think it may finally, for example, start using more best practices. A great example is the city of San Diego has adopted a by right, largely housing permit approval process, which is legal under state law, but most cities have not gone there. And they have a terrific internet interface that allows you to know where your application is sitting, like whose desk for how many days. And just that transparency of whose desk how many days has incredibly accelerated the process, as opposed to who knows, or, oh yeah, I forgot that guy was on medical leave. He'll be back in 3 or 4 months. And you're like, wait, I need this. So there's simple stuff like transparency and accountability for permitting that unfortunately implicates computer procurement and other bureaucratic hurdles that are susceptible to change with strong leadership. There are other issues like infrastructure designs or evacuation routes or with the roads that are a surrogate in my mind for Nolan's notion. I appreciate, by the way, that the organization is more has reached consensus around urban infill, but not everyone wants to live in an 800 square foot apartment and raise their family. And that's what we're sort of set up to permit now in our infill locations, and they're not penciling. And so from my perspective, the lack of respect for all the scholarship that says if you have a growing population, you have to be able to grow out, not just up, if you want to keep housing affordable, attainable, and actually take care of the full spectrum of needs, not just the sort of luxurious dorms that we like to create in apartment blocks. Or at least permit and then not create because they don't pencil. So we got to get past the whole debate. We just spent 3 or 4 years turning ourselves and our local governments into pretzels, requiring that they approve new general plan housing elements that say, here's where housing can go, and if it goes here, we will meet our fair share of the housing demand. From my perspective, what isn't happening and what really needs to happen is if you're in a location where a state-approved housing element says housing should go, you should be able to build that housing. submit a building permit, get the approval. We're done debating about whether it's a good idea to build housing or what density or what style or whatever. You should be able to build what you've planned for and approved. And those have been approved at the elected city level or county level and approved by our state housing agency. Basta. They have 8-year runs. We should just let them go and stop the fighting over siting.
Yeah. So we should be able to build is a great slogan that I think I certainly can agree with. I'm reluctant to say that there's a silver lining to so much death and destruction. It may be that this may help more people realize that various kinds of zoning and other restrictions are a big obstacle to affordable housing and therefore stimulate momentum for getting rid of at least some of these restrictions. We'll see if that happens or not. More generally, I hope we can figure out ways to make more people realize two things. One is that making it easier to build new housing will increase the amount of housing and reduce prices. You might think that's very obvious, but a lot of survey data suggests many people don't get that. And that's actually a big source of opposition to housing construction, that they think it won't actually reduce prices or that a few rich people will get all the benefits or something like that. There's a lot of ignorance out there on that point. And then a second thing on which many people don't sufficiently focus on is that this is a huge restriction on what property owners can do with their land. Many people on the right who otherwise care a lot about property rights, they don't get that, but also other people, don't get it either. And again, survey data shows that if you ask people in the form of should property owners be able to build, homes of their choice on their land, 60-70% of the public will answer yes, even though if you ask a similar question about developers, you'll get a much lower percentage of people saying yes. So if more people understand that this is a severe restriction on property rights, and B, allowing more construction, particularly of multifamily housing, would reduce prices and make housing more available, I think can generate more support for the needed reforms of the sort that we've been talking about today.
Great.
Yeah,
Nolan, go ahead.
I want to take this in the totally opposite direction from what you asked, which is we need to reckon with the stakes of the moment. There's a very real possibility that 10 years from now, Altadena and the Palisades still looks like a burned down wasteland. Mm-hmm. That's the trajectory we're on. And we know this has happened. Look at the fire affected areas in Western Malibu. Look at the fire affected areas in Maui. There's been a lot of great reporting on this, including from Christian Britsky over in Reason had a whole story about this of Maui burned down and virtually nothing has been built back because they didn't create a safe harbor for all the environmental regulations. They didn't create a safe harbor for their equivalent of coastal commission reviews. Now, there are conversations around stuff like this, but so far the carve-outs have been very, very limited. And I would just stress that. We don't want to live in a world where 10 years from now, these communities are still burnt down or maybe a handful of very expensive single-family homes, and most people are still out on what was at one point their most valuable asset. So, but avoiding that path is going to require some serious change, and some change that's going to be controversial, and some change that hopefully can stimulate broader conversations around regulatory restrictions on housing production and permitting delays in California. I don't want to live in that world where I come back in 10 years and Altadena is still burned down. I would like to come back to an Altadena where everybody's built exactly the type of housing that they want and need, and we have a beautiful, thriving community there again.
Great. With that, I want to. Oh, did you have any thoughts, Jennifer? Or
no,
you just want to
big thumbs up.
All right. Well, I think that's a perfect note to end on. I want to thank our panelists very much, and please check out their bios on the FedSoc website, as well as I believe we've put some links to their scholarship, which is excellent. And I want to thank FedSoc, Federalist Society, for hosting this webinar. Turn it back over to Edith.
Yeah, on behalf of the Federalist Society, thank you so much to Nolan, Jennifer, and Professor Soman for speaking with us today, and to Steve for moderating. We're so grateful for your time and expertise. Thank you also to our audience for joining us. We really appreciate your participation. You can stay up to date with announcements and upcoming webinars on our website, fedsoc.org, or on all major social media platforms. Thank you once more for tuning in, and we are adjourned.